Welcome to the weekly business meeting of the South Carolina Public Service Commission, and thank you for joining us. Today is Thursday, October 31st, 2024. It's approximately 2 p.m. Before we begin the meeting, would you please join me in a moment of silent reflection? Thank you very much. Present in the hearing room today, as far as commissioners, we have Commissioner Belser, Commissioner Caston, Commissioner C. Williams, Commissioner Thomas, and I'm here, Chairman Powers. Virtually, we have Vice Chair Justin Williams.
Excuse me, Vice Chair Powers?
Yes.
Hey, okay. Just wanted to make sure I had audio. I have video. I have audio, but I didn't have video. But I have video now. Thank you, sir.
We got you. Thank you. Mr. Scarborough, if you would, please proceed.
Yes, sir. The first order of business is to set the next regularly scheduled business meeting. Staff recommends that the next commission business meeting be set for Thursday, November 7, 2024 at 2 p.m.
The next meeting will be November 7th at 2 p.m.
Thanks, sir. Today we have just 4 items on the utilities agenda and 4 items on the transportation agenda. Item number 1 is in docket number 2024-247W. This is a request from Upstate Water Resources Incorporated for expedited consideration of its application to transfer stock and a new performance bond agreement.
Having heard item 1 as read by Mr. Scarborough, do I hear a motion?
Chair Powers, I'd like to make a motion.
Mr. Caston,
I move that the Commission adopt the provisions of the settlement agreement filed on October 11th, 2024, and entered between the parties, Upstate Water Resources Incorporated and the Office of Regulatory Staff, and that the Commission approve the application of Upstate Water Resources Incorporated to transfer stock. I further move that the Commission grant the company's request for expedited consideration and waiver of notice. Additionally, I further move that the Commission approve a new performance bond agreement. Company shall file a personal financial statement in the amount of $200,000 in Mr. Burton's name and using Mr. Burton's assets as surety in compliance with South Carolina Code annotated 58-5-720. UWR, Upstate Water Resources, must correct its customer bill form within 10 days from the date of the final commission order as follows. Remove the template line item making reference to the South Carolina state sales tax. Add the company's contact telephone number as required by South Carolina Code Regulation 103-732.2K. Amend the bill language related to late payment fees to comply with South Carolina Code Annotated Regulated 103-732.3. Add the contact telephone number and email address of the ORS as required by South Carolina Code Annotated Regulated 103-732.21. I so move.
thank you. Motion has been made by Commissioner Caston. Is there any further discussion?
Chair Powers,
Commissioner Williams.
I have a question. I noted that Commissioner Caston read the regulation as 103 in B as 103-732.2K. So I am wondering if in D that regulation instead of being 103-732.21 would be instead L.
I wondered the exact same thing as I read it. I think that is so subject to confirming that.
We'll confirm whichever way it's supposed to be, but I think we can go ahead and consider the motion. Do a roll call of commissioners, beginning with Commissioner Caston.
Aye.
Commissioner Thomas.
Aye.
Vice Chair Williams.
Aye.
Commissioner Williams.
Aye.
Commissioner Belser.
Aye.
And I vote aye. The motion carries.
Item number 2 is deleted from today's agenda. So item number 3 appears in docket number 2024-285E. This is a request from Duke Energy Progress, LLC for expedited consideration of its application for approval of a special electric service agreement under Act 220 and a request for confidential treatment of Exhibit A of its application.
As to item 3, do I hear a motion?
Mr. Chairman,
Commissioner Belser.
thank you.
I move that the Commission grant the request of Duke Energy Progress LLC for expedited consideration of the company's application related to a special retail service agreement with AESC Florence LLC, and further move that the Commission approve the special retail electric service agreement between Duke Energy Progress LLC and AESC Florence LLC. By its application dated October 16, 2024, DEP states that it will build a new 115/24 kV industrial substation off an existing 115 kV line in order to meet AESC's load requirements. Under the service agreement, the company will plan for, install, and maintain all facilities necessary to meet all of the customer's electricity needs under this Phase 1 service agreement, which will require significant investment. Additionally, Duke Energy Progress states that the approval of the service agreement does not require a determination of Duke Energy Progress's entire rate structure or its overall rate of return, or result in an increase in rates. In a letter submitted on October 28, 2024, the Office of Regulatory Staff states that it does not object to the Commission's approval of the service agreement. As recommended by the Office of Regulatory Staff, I further move that Duke Energy Progress be required to provide ORS and the Commission with annual reports related to the service agreement to demonstrate that the total cost of the transmission facilities and the return on the transmission facilities are being completely offset by the rates and charges specified. I also move that the Commission find that the right to fully examine the associated cost, accounting treatment, and project activities for reasonableness and prudency, and the right to make recommendations concerning rate-making treatment during a future appropriate cost recovery proceeding is reserved for Duke Energy Progress, the Office of Regulatory Staff, and any intervening parties of record along with the Commission. Finally, I move that the Commission grant the request for confidential treatment of certain portions of the service agreement between Duke Energy Progress and AESC Florence, due to the commercially sensitive and proprietary nature of certain provisions within the service agreement. The release of such confidential provisions is protected from disclosure under the Freedom of Information Act. A full order of the Commission detailing this decision will be issued. That's my motion.
Thank you, Commissioner Belser. Having heard the motion by Commissioner Belser, is any further discussion? Hearing none, we'll proceed to a roll call vote, beginning with Commissioner Belser.
I vote aye.
Commissioner Caston.
Aye.
Commissioner Thomas.
Aye.
Vice Chair Williams.
Aye.
Commissioner Williams.
Aye.
And I vote aye. The motion carries.
Item number 4 appears in dockets numbered 2023-8E and 2023-10E. This item involves final disposition of this docket.
Having heard item number 4 is presented by Mr. Scarborough, do I hear a motion?
Mr. Chair.
Vice Chair, you have the floor.
Thank you, Mr. Chair. Mr. Chair, fellow commissioners, subject to the directives specified below, I move that the Commission approve the Duke Energy Progress LLCs and Duke Energy Carolinas LLCs 2023 Integrated Resource Plan filed on August 15, 2023, as updated by the Supplemental Planning Analysis filed on January 31st, 2024. The company's Integrated Resource Plan is subject to the limitations imposed by South Carolina Code Annotated Section 58-37-40, paragraph C4. As such, the Integrated Resource Plan is not, and I quote, not determinative of the reasonableness or prudence of the acquisition or construction of any resource or the making of any expenditure, end quote. And the companies, quote, shall retain the burden of proof to show that all of its investments and expenditures, are reasonable and prudent when seeking cost recovery and rates, end quote. For the IRP process going forward, and for evaluation and reporting in future IRPs and IRP updates, Duke shall do the following. Number 1, Continue assessing federal funding opportunities for the benefit of customers, including evaluating whether the Energy Infrastructure Reinvestment Program would provide cost-effective funding opportunities for any of the company's future investments. The company shall continue providing updates to the Commission on federal funding opportunities under the IRA and the IIJA in docket number 2023-319A and discuss future updates related to the IRA, IIJA, and EIR program with stakeholders in a collaborative process. Modeling adjustments resulting as needed from these funding opportunities or from the stakeholder collaborative shall be incorporated in the next comprehensive IRP. The company shall also keep ORS and stakeholders informed of the consultant's EIR report, provide a draft of the consultant's report to the Office of Regulatory Staff and stakeholders when the draft is available, and file a copy of the final EIR report with the Commission and the parties on or by May 1st, 2025. Number 2, while recognizing the company's solar resource availability limits used in the modeling for this IRP, this 2023 IRP, I should say, are supported in the record and reasonable for planning purposes at this time, the Commission directs the companies to continue evaluating the reasonableness of solar resource availability and interconnection limits in the next IRP and IRP update. Additionally, the company should continue to build upon the Carolinas Transmission Planning Collaborative and other collaboratives as are related to expand coordination with members and stakeholders and continue proactive planning of transmission projects. Expanded coordination should include review and, where appropriate, implementation of strategies to facilitate greater interconnection of renewable resources through transmission expansion, including but not limited to proactive planning through the multi-value strategic transmission planning process, identifying cost-effective, least regret transmission upgrades, expanded use of provisional interconnection services, and synchronized proactive transmission and generation planning that evaluates long-term high-voltage transmission expansion and short-term solutions, such as grid-enhancing technologies and strategically sited batteries. Number 3, the companies are directed to continue work and collaborate with interested stakeholders to develop opportunities for more customer-sided generation to help reduce loads and to accomplish the sustainability goals of companies such as Walmart. Continued collaboration may include working toward a specific target of customer-sided generation as recommended by Walmart for inclusion in the next comprehensive IRP. Number 4, Duke is also directed to report on the 22% reserve margin in its next IRP update and thereafter each year in either the IRP update or comprehensive IRP to ensure that the 22% level of reserve margin remains appropriate considering any changes in Duke's loads, assumptions, progress with the merger, or other factors that could impact the reserve margin. Number 5, the companies are directed to engage with the Office of Regulatory Staff and stakeholders in the stakeholder process on the need for formal benchmarking of production cost modeling. Further, the company should address in their next comprehensive IRP the steps taken to address the recommendation of the Office of Regulatory Staff for benchmarking of the modeling process. With regard to recommendations presented during the hearing that encouraged development of new programs such as Bring Your Own Battery, and the Power Pair pilot in North Carolina, those programs are better discussed in the EEDSM collaborative than in an IRP proceeding. And the companies are directed to engage with stakeholders in the EEDSM collaborative on potential development of new EEDSM programs, including the programs discussed in this docket. Number 7, the companies are directed to continue stakeholder engagement and discussions to determine if any changes are warranted in the IRP update as the result of changes in the market, changes in policy, and/or changes in technology. Number 8, the companies are directed to review and address the recommendations from the Office of Regulatory Staff as part of the Stakeholder Working Group or the 2025 IRP update. If the recommendations are not followed or adopted, the companies should explain in the 2025 IRP update. Finally, I move that the Commission strike the Office of Regulatory Staff's motion. I move that the Office of Regulatory Staff's motion to strike, filed on September 6, 2024, be denied. With regard to the Office of Regulatory Staff's motion for declaratory judgment and taking into account the evidence of record from this proceeding, I move the Commission find that the issues presented in the motion do not present a justiciable controversy. The Commission's order will further address the motion to strike and the motion for declaratory judgment. So moved, Mr. Chair and fellow Commissioners.
Thank you, Vice Chair. Having heard the motion by Vice Chair Williams, is there any further discussion?
Chair Powers.
Commissioner Thomas.
Thank you. I appreciate that. Vice Chair Williams, very respectfully, I will not be supporting your motion. I believe this commission has an obligation to weigh each of the balancing factors, including consumer affordability and least cost, so that I fully comply with my obligation to review this IRP under South Carolina law and on behalf of South Carolina ratepayers. We're trying to determine whether the plan represents the most reasonable and prudent means of meeting the company's energy and capacity needs as of the time of review. Unfortunately, without a resource plan developed to comply with the Section 111 federal requirements, without the interim 70% carbon emissions constraint, I cannot determine whether the plan appropriately balances each of the factors pursuant to SC Code annotated Section 583749C2 A through G. In my view, I cannot fulfill my obligation under the law by approving an IRP without fully accounting for consumer affordability and least cost, which is a very important balancing factor to me. I need additional information in order to make a fully informed decision as recommended by ORS. At a minimum, I believe this additional information will serve to complete the record, which will enable the Commission to complete its work in this matter and to uphold its obligation to the citizens of South Carolina. I make no prediction and no prejudgment as to what this new information may reveal, if anything. Likewise, I cannot predict whether additional modeling will make the P3 fall-based portfolio any more or any less reasonable. In any case, I believe this commission must continue to give the appropriate deference to the company in all of its business decisions. However, simply put, I need more information. Thank you for allowing me the opportunity to make these comments.
Thank you, Commissioner Belser. Commissioner Thomas. Vice Chair, did you want to respond to that, or?
Well, I think I would like to give everyone an opportunity to if they have something to say, considering I read that extremely long motion. I think it's fair to give everyone an opportunity to share their position, and then if necessary, I'll respond if that's okay with you, Mr. Chair.
That's fine.
And Commissioner Thomas.
Mr. Chairman.
Commissioner Belser.
Thank you. Commissioner Thomas, respectfully, I have a slightly different position than you do. We've got six minds up here, and it's on certain cases it may be okay to have 6 minds thinking alike, but I can certainly appreciate that on other cases 6 minds are not going to be in total agreement. Mr. Chairman, first of all, I'd like to thank the companies, the ORS, and the other parties of record for the significant work that they put into preparing and presenting their cases. This is a complicated case, and it's evident from the parties' presentations, that they've expended considerable time and resources to present their positions to this commission. We have a robust record before us, numerous volumes of transcript, numerous hearing exhibits, and there's a lot of information to go through. Similarly to what Commissioner Thomas said, I recognize that it is my responsibility and duty to fairly and impartially review the evidence and render a decision applying the law to the facts presented in the record. That is my duty. It is a duty that I take seriously and one that I try to discharge to the best of my ability. With that said, I do recognize this is an important case, and I also recognize that with 6 commissioners, we may each view the evidence in different ways. I appreciate the work of my colleagues and the commission staff who have put in a lot of work to help me as I've worked through this case. I appreciate the discussions that I've had with individual commissioners, with staff members, and in the allowable briefings we've had to discuss this matter. But after going through the hearing process and then continuing to review the record along with the proposed orders and briefs and the discussions with colleagues, I would find and conclude that the companies have complied with the requirements of South Carolina Code Annotated Section 583740B1, which enumerates all the elements that an electric utility must include in its integrated resource plan. I would also find and conclude, based on my review and analysis of the evidence of record against the balancing factors contained in 583740C2, that the companies have sufficiently addressed each of the balancing factors. My review and conclusion leads me to support the company's IRP as the most reasonable and prudent means of meeting the company's energy and capacity needs as of this review. The companies operate dual state systems. This is a fact and has been ongoing for many, many years. And the operation of the dual state system has been under the purview of the Public Service Commission for those many, many years. In my opinion, any concern or worry about the operation of the dual state system is irrelevant. The record is replete with benefits and efficiencies from the use of the dual state system to South Carolina ratepayers. The companies are required to meet and comply with the laws of North Carolina and South Carolina, as well as federal laws. However, in meeting the requirements of law in North Carolina does not mean that the companies ignore South Carolina law in favor of North Carolina. As stated in testimony in the record, it is possible for the companies to meet the requirements of both states. I believe it may have been stated that 2 things could be true at one time. And I find evidence in the record to support a finding that the companies are meeting through this IRP are planning to meet the requirements of both state laws and federal law. Under the recently finalized Section 111 rule, Duke must retire its coal plants by January 1, 2032, or face significant costs to conduct certain upgrades depending on which pathway the companies may pursue. Additionally, there is no evidence in the record that the companies are not accelerating coal retirement dates as a result of the requirements imposed by North Carolina law. This proceeding is solely focused on resource planning. It does not address cost recovery, which the General Assembly codified in South Carolina Code Annotated Section 583740C3. And pursuant to that code section, it is clear that the Commission's approval of an integrated resource plan or the inclusion of a specific resource within an integrated resource plan shall not be determinative of the reasonableness or prudence or of the acquisition or construction of any resource or the making of any expenditure. An electrical utility does retain the burden of proof to show that all of its investments and expenditures are reasonable and prudent when seeking cost recovery and rates. This is the law that the companies must follow as to its South Carolina operations, and it must and will be followed. With regard to additional modeling, I think that what we see happening in the federal Rule 111 that was recently enacted and not stayed by any court, although it is under appeal, but it is currently, as was stated in the hearing record, the law of the land. It is my opinion that that rule from the EPA really renders a good bit of what was in North Carolina law irrelevant. I'm in favor of the motion, and in particular, I want to point out, I believe it was subsection 8 of the motion that Vice Chair Williams wanted. I recognize that the Office of Regulatory Staff made a recommendation for further modeling. Whether or not that is appropriate in an IRP update or in the next comprehensive plan, I think that paragraph 8 that I seem to have lost somewhere would allow the company and ORS to discuss what the needed requirements are for ORS's request. Things are changing quickly in this realm, the energy sector. There are advancements daily in technology. There are other issues that are also need to be considered. And one of the reasons that I support that position, that paragraph of the motion, is that I think that it would behoove everyone if the companies and ORS got together and fully vetted what might be needed in an additional modeling run, given on changes that are happening. It could be that ORS still wants the companies to run the model that they put forth in testimony. However, after discussing and seeing where things are with the EPA's law, with other laws, and with what's transpiring, it may be a totally different, or it could change a little bit, it could change a lot. We don't know. But my duty is to respond to this matter that is before us today based on what has been presented. And for those reasons, I'm comfortable with my conclusions that the IRP meets the statute here in South Carolina, and I am supporting the motion. Thank you.
Thank you, Commissioner Belser. Any further commissioner comments? Well, I do have a couple things. Vice Chair Williams, I will be supporting your motion. As I was flipping over my calendar at lunchtime today with November coming up, it occurred to me that in about 2 weeks, it will be 47 years since I was sworn as an attorney. During that time, I have tried a lot of cases, both criminal, civil, and otherwise administrative. This case makes me think, I know there's some talk of our discretion or what we can ask for, but the record itself is closed in this case. I've seen several cases where a jury would come in and they'd ask a judge we'd like to hear so-and-so testify. We'd like to hear this, that, and the other. And the judge always said, no, you have a record, you have what you have, and you got to decide it on what you got. And deciding on what we have before us with the recommendations that things be done almost immediately with the 2025 update and beyond, then I feel it's best that we move forward. This is the technology is moving faster than anybody can imagine. And it's so hard for utilities who have to have physical plants and have to have the abilities to provide the necessary electricity and power for companies to operate. It's almost impossible to keep up. And we cannot, I feel, delay what really is a major part of development in this state, and to keep things moving. And it's a plan. It can change. It can be updated. There are recommendations, and the stakeholders working group does a good job, and I feel they'll continue to do a good job. But Vice Chair Williams, I will be supporting your motions based upon the law and just the experience I have. Thank you. Any further comments?
Mr. Chair,
You have the floor.
thank you, Mr. Chair. I just wanted to briefly respond to my good friend, Commissioner Thomas. I appreciate not only your friendship, but the work that you put into reviewing this case and getting to your decision. I echo Commissioner Belzer's sentiments that just because we agree on most things does not mean we have to agree on all things. And I'm sure that reasonable minds can differ. I tell you, being at the PSC for over 6 years, I've seen a lot in that short period of time. And what's striking to me is that this IRP was probably one of the more, if not most, transparent IRPs that we've seen since they started filing them at the commission. It may have been one of the longer hearings as well. I think the company put forth a case that was robust, and I think they anticipated as many questions as they could. Also appreciate the interveners and the Office of Regulatory Staff. They definitely vetted the case and offered their not only observations, but also recommendations. With that said, it seems to be some level of consternation or concern about South Carolina ratepayers as it relates to the potential affordability of the company's plans. We all know that we are South Carolina commissioners, and our oath of office is taken in South Carolina, and it's to uphold South Carolina law. This case is about South Carolina law. It's South Carolina law as it relates to a system that operates in both North and South Carolina. Our task here is to find and determine whether or not the energy or the IRP, I should say, is the most reasonable and prudent for meeting the utilities, in this case, the system that spans North Carolina and South Carolina, meeting the energy and capacity needs at the time of filing. I don't think we could find an IRP that doesn't meet the legal requirements of the company system in the North Carolina portion of the system reasonable and prudent, simply because it will violate the law in a portion of the system, which comes along with a host of other issues. I echo the chair's sentiments. Just because North Carolina has a law that may not exist on the books in South Carolina doesn't mean that law violates South Carolina law or harms South Carolina ratepayers who have benefited from the system that operates in both North Carolina and South Carolina for an extensive period of time. And the record shows that South Carolina ratepayers have benefited from that system and has shared some costs. So I respect your position, Commissioner Thomas. I can understand the need for wanting more information, but in the confines of this proceeding, the information we received is enough, in my opinion, for us to make a decision and to adopt or approve the IRP as presented. Thank you.
Thank you, Vice Chair Williams. Any further comments?
Chair Powers.
Commissioner Carolyn Williams.
Thank you very much. I agree with a lot that has been said this morning, particularly the kudos that are this afternoon, especially the kudos that Commissioner Belzer offered, and thinking about where IRPs were in 2020 when some of us came on the commission and where they are today. And the companies and all of the interveners, I suspect, should be proud about where we've come from and where we are, and that it was a maybe not collaborative in the production of the plan, but the process that leads us to this hearing room is iterative, and I suspect that each of you has each of those involved has come out better for the discussions that have happened there. Beyond that, I'm going to do something kind of daring for me, because some lawyers have said that, that they personally feel that this IRP has met the requirements of the law. And we as commissioners sit as judge and jury. We have a preponderance of the evidence that needs to be met. And personally, I look at the statute and I look at B1 that talks about an integration resource plan shall include the following. And I could put check marks by everything there. C1 is where our role as a jurist and a judge is brought into question. And that's where we are looking at appropriately balancing the following factors. And that's an independent decision. And so you can tell from what I've said thus far, I'm unfortunately not going to be able to support the approval motion, but it has to do with the components of how I personally assess the factors in C1 and some of the parties that also had concerns with elements from C1. So respectfully, I'm not going to be able to support Vice Chair Williams's motion to approve this IRP. Thank you, Chair Powers.
Thank you, Commissioner Williams. Any further comment? Commissioner Williams, you address it. Someone's sharing legal advice. This is staff. Is it staff's not some ex parte advice you've been given?
He was referring to the lawyers on the commission.
I was entirely.
Okay.
I was just, I do not debate you all very often, but I was trying to kindly push back on the idea that, and really just say positively, several of you feel that this IRP has met the standards and the requirements of the law. I'm just speaking for myself, and I feel like I have the right and the background and the understanding to say that I don't think it got to that 50% line plus whatever it takes. And that's just for me personally. So that's what I was trying to address in a kind way.
Well, I do not question that whatsoever. You certainly have the ability, the authority, and legislatively you've been elected to do exactly what you're doing. You just said some lawyer didn't say a name, and it kind of, want to make sure we were still all on track. All right, if there's no further comment, the motion on the floor is to approve the IRP with some 8 or 9 different instructions as to future updates and IRPs. We will proceed with the roll call vote, beginning with Commissioner or Vice Chair Williams.
I vote aye.
Carol Lee Williams,
Nay.
Commissioner Belser,
I vote aye.
Commissioner Caston,
No.
Commissioner Thomas,
No.
and I vote aye. The motion fails due to a tie.
Chair Powers,
Commissioner Caston,
if appropriate, I would like to make a motion.
you have the floor.
And before I do, and this is not part of the motion, I just listen to the comments by all parties. And what a wonderful group of people to work with. They can be aggravating at times, but I know I am too. Just a great group. And I believe, and I've said this and have experienced, that good people can hear, read, and see the same information and come to different conclusions. And also, I guess along the lines of perhaps what Commissioner Thomas said, I don't believe it's asking for a big lift or a big ask to require the companies to run a portfolio as requested by ORS. And for me to make an informed decision, the best decision I can make, to determine if it is the most reasonable plan, ORS's request to have this model run to make this decision, I believe, is absolutely appropriate. And as I say, I don't think a big ask, a big lift, or a big deal, but that's me. Having said that, I'd like to read a motion. I move that the Commission modify Duke Energy Progress LLC and Duke Energy Carolinas LLC 2023 Joint Integrated Resource Plan filed on August 15th, 2023, as updated by the Supplemental Planning Analysis filed with the Commission on January 31st, 2024. Act 62, codified in South Carolina Code, annotated Section 583740, sets forth procedural and substantive requirements for utility IRPs, IRP filings, along with the standard of review for the Commission's review. As the agency charged with the responsibility of interpreting and enforcing Act 62, the Commission must determine whether the Integrated Resource Plan is the most reasonable and prudent means of meeting energy and capacity needs, and the Commission, in its discretion, shall consider whether the plan appropriately balances additional factors. Although Duke Energy's 2023 IRP meets many of the requirements of Act 62, certain factors have not been met, particularly relative to consumer affordability and least cost, as well as federal environmental regulations. I move that the companies modify the 2023 comprehensive IRP by providing a resource plan developed to comply with the requirements of Clean Air Act Section 111 Final Rule without an interim 70% carbon emissions reduction constraint, as requested by ORS in the current comprehensive IRP. This portfolio shall fairly evaluate using the min-max regret analysis framework for performance under CO2 price, fuel price, and capital cost sensitivities. For the next IRP update, the companies are directed to do the following: conduct production cost model benchmark studies on an ongoing basis, such as once every 3 years ahead of comprehensive IRP proceedings, and report the results in the stakeholder working group. Consideration of a nodal approach to production cost modeling shall be given. Comply with Commission Order 2023-189 to model both company-owned and power purchase agreement solar as selectable resource options, and arbitrarily limit the selection of PPA solar resources. The companies and the parties, and all parties to this matter, shall continue stakeholder engagement and discussions to determine if any changes need to be made to the IRP update as a result of changes in the market, changes in policy, and or changes in technology. Companies must provide ORS and stakeholders with regular updates on the consultant's energy infrastructure reinvestment report and a draft of the report when it's available, and file a copy of the final energy infrastructure reinvestment report with this commission no later than May 1st, 2025. The company should pursue all effective strategies to facilitate greater interconnection of renewable resources through transmission expansion, including, but not limited to, conducting synchronized proactive transmission and generation planning that evaluates long-term high-voltage transmission expansion and short-term solutions, such as grid-enhancing technologies and strategically sited storage, such as batteries. Companies must incorporate more fully distributed energy resources in future IRPs by incorporating behind-the-meter storage in their IRP modeling and including the impacts of managed EV charging on the EV load forecast. Companies must work with stakeholders to develop a specific target of customer-sided generation to help reduce loads and to accomplish the sustainability goals of companies such as Walmart. Continued collaboration may include working toward a defined target of customer-sided generation as recommended by Walmart for inclusion in the next comprehensive IRP. Companies are also directed to reevaluate the need for a 22% reserve margin in their next IRP update and thereafter each year to ensure that any change in its load assumptions progress with the DEC-DEP merger, Duke Energy Carolinas and Duke Energy Progress merger, or other factors would allow for a lower reserve margin. The companies must include in their next IRP update an evaluation of new residential and small commercial bring your own battery pilot program and include preliminary exploratory modeling of the evaluated bring your own battery program as a selectable supply side resource in the capacity expansion model. I move that ORS's motion to strike filed on September 6, 2024 be denied. With regard to ORS's motion for declaratory judgment and taking into account the evidence of record for the proceeding, I move the Commission find that the issues presented in the motion do not present a justiciable controversy. The Commission's order will further address the motion to strike and the motion for declaratory judgment. Any ordering provisions from the company's previous IRP decisions that have not already been addressed by the companies should be incorporated in ongoing stakeholder engagement, potential negotiations, testimony of comments for the next company's IRP update. Companies are directed to review and address the ORS recommendations introduced in this docket, and any such recommendations that are not implemented should be explained by the companies in their next IRP update. I so move.
Having heard the motion by Commissioner Caston, is there any further discussion? Commissioner Caston, there was one point at earlier, because that's the first I've heard of it. You talked about an update. What time period are you talking about updates need to be made or reviews turned in?
These updates for the next IRP update, which would be whenever the next update is. And I think that's still to be determined. It seems like 2025, but I didn't want to put a year.
You're correct.
A year.
Any further discussion?
Mr. Chairman,
Commissioner Belson.
Commissioner, respectfully, I'm not able to support this motion, but I am a little bit concerned about updates on potential DSM-EE. And I'm sorry I didn't follow everything in your motion, but are those programs that have already been implemented? Because we have an EEDSM collaborative that the companies and stakeholders work through. And if those are new programs that, I recall from the testimony there was some, and I'm not sure which ones you referenced, but there were new programs that were suggested in this IRP, and those really are not appropriate for evaluation in the IRP. Those need to work through, in my opinion, need to work through the EEDSM collaborative. So to the extent that you reference those, were those programs that are already approved, or those programs that were suggested as possible programs because they're being used in other states, as was some of the testimony in this record?
Well, as far as at least my understanding of some of that testimony also was that as a matter of running a model and using inputs for particular portfolios or models, that such as this program, say similar to behind the meter programs like Walmart would suggest, inputs into a model, it's
No, I'm asking, I thought you referenced specific programs, and I didn't catch which ones they were.
the companies must include in the next IRP update an evaluation of new residential small commercial BLE battery programs or pilot programs and include preliminary. And I agree that if it's a program that's new, it would be in the EEDSM.
Okay, all right, thank you.
Commissioner Caston?
Yes.
As I read that recommendation and thought about the relevance, and I may have I don't know if there's an amendment that's needed, but I think the rationale of EEDSM programs being considered at the IRP level has to do with the idea of peak projections and the impact of EEDSM. So I do not think that your motion intended, but we may need some clarifying verbiage, that this was not about the place to develop the program, because I agree with Commissioner Belzer, that would be in with the EEDSM collaborative and through that docket. But the impact of those programs, and I think the motion was about including the effect of those programs and not the actual implementation of them.
That is correct. And the motion's on the table, so any suggestions or recommendations to ameliorate things, clean them up, clear them up, I'll be glad to consider those.
It could be as simple as the companies must include in their next IRP update an evaluation of the impact of, and then it would continue.
Agreed. Is that
I can read it all, but
a friendly amendment?
that's a friendly amendment.
Okay.
The
I think
impact of the new
The problem
resident.
is, my recollection is that I think you referenced the Bring Your Own Battery program, did you not?
I did.
And I think that was a recommendation that the company pursue that, and so a recommendation
take
from an
that.
intervener. I may be wrong, but I think that the recommendation was that the company pursue a Bring Your Own Battery program, and
It was, I think, from the intervener side. And point well taken, and I'll gladly include that friendly amendment.
Any further discussion?
Mr. Chair,
Vice Chair Williams.
I just wanted to tell my favorite Clemson Tiger, Commissioner Caston, that I appreciate his hard work on this motion, but respectfully, I will not be able to support it for the reasons I've already stated. But I appreciate the work that he put into it, and I understand his position.
Thank you, Vice Chair. Any further comments or discussion? Commissioner Williams.
Thank you, Chair Powers. This is just for clarity for those listening, and really boiled down to just a few sentences. I think the reason that I'm supporting this motion has to do with primarily two balancing factors related to affordability and cost, but then also related to meeting federal requirements, and that in order to make a decision to approve this IRP, I feel that I need that information to be most aptly informed. Thank you.
Thank you, Commissioner Williams. I would only add to that, as far as any federal requirements, those have to be met regardless of what an IRP says or does. That's separate from anything we do. All right, anything else? All right, the motion on the floor is to modify the IRP.
well, it says that the commission modify, and I don't think the commission can modify it, but the commission can order the company to modify it, but we
Commission.
can't modify it.
Commission
Correct.
ordered the company to modify the
Let's go
IRP.
by the language of the motion.
Thank you very much. We will proceed to a roll call vote, beginning with Commissioner Caston,
Aye.
Commissioner Thomas,
Aye.
Vice Chair Williams. Can't hear you.
Respectfully, I vote no.
Commissioner Carolee Williams,
Aye.
Commissioner Belser,
I vote no.
and I vote no. The motion fails.
Chair Powers,
Commissioner Carolee Williams.
I have a motion to offer. My motion is to approve the original motion as read by Vice Chair Williams with the addition of the following paragraph, proposing that it become the new number 1 in that paragraph, in that motion.
Well, I think you're on the side of the party, the prevailing side. You can ask that the motion be reconsidered, but all we could reconsider would be the actual motion. You can certainly make a new motion using her motion and adding a paragraph.
That is what I'm intending to do. That's what I thought I.
That's the way Robert wants it done.
Right.
Thank you. Go ahead.
So I'm just going to, because it was a lengthy motion, I am just going to read the relevant parts. But that motion, the original motion to approve, and this would be under the idea of approve, this would be an approval of the IRP. But where it says for the IRP process going forward and for evaluation and reporting in future IRPs and IRP updates, Duke shall engage and work with ORS to develop and discuss number A, modeling either a resource plan that complies with the Clean Air Act, Section 111, final rule requirements without an interim carbon emissions reduction constraint or other resource plans as may be determined in those discussions. And B, whether that additional modeling should be conducted as part of the company's 2025 Integrated Resource Plan update or the 2026 Comprehensive Integrated Resource Plan. The Commission may choose to hold a hearing on the 2025 Integrated Resource Update. And I have some comments at the appropriate time.
You have the floor.
What the human nature element that keeps rolling in my mind is you don't want to let the goal of perfection get in the way of doing good. And in that spirit, I've got a couple of reasons for my motion. No decision on this IRP doesn't help anyone in South Carolina. And as a trained planner who spent my life working on plans, I feel like I am best able to say, well, a plan is best when the data is fresh. This data comes from August of 2023 with the supplemental updating that as well. So already we're around 14 months old. And so in a state and a balancing system that's changing rapidly, and others have talked about the technological changes that are happening, I'm recommending for South Carolina and for the Duke Energy's territory that there is great value in letting the company move on toward their updates and toward their comprehensive 2026 IRP. It's not my first choice, but it is a compromise that I'm offering. Thank you, Chair Powers.
Thank you, Commissioner Williams. Is there any further comment?
Mr. Chairman, I have an amendment.
Commissioner Belser.
I move to strike the sentence dealing with the commission may choose to hold a hearing on the 2025 update. The statute doesn't talk about a hearing. However, there is the inherent power and authority under commission regulations, and I believe statutes as well, that commission could choose to hold a hearing. I just don't think that it's needed in the motion. So, Commissioner Williams, I respectfully ask to amend to strike that sentence.
I didn't hear that it wasn't couched. Thank you. Thank you. Can we vote on that amendment?
It's an amendment. Yeah, I'm not offering as a
Right.
friendly amendment.
Right.
It's not a friendly amendment, so it's a motion to amend that requires a vote.
Could I say this regardless of
Commissioner Cass, of course, I mean, if we can do it, I don't know that we have to say it, it's the law, but, go ahead. Commissioner Cass.
there's a lot of moving parts here, and I'm really trying to follow them all. I have a concern that I want to make the right decision for the right reasons. I want to do this the right way, the best way. And I'm getting concerned about the ability for me to do that as well as I'd like to. Having said all that, and man, I hate to put things off. Don't even know if we could. But if we could, whether it's tomorrow, Monday, Tuesday, I don't know. I'd kind of like time to maybe digest some of this and make sure I understand this well, but that's my thought.
Commissioner Caston, if we were reconsidering the original motion, we could entertain a delay on it, but we're considering a new motion now, and I think we would have to vote on it.
Chair Powers,
so-
I'll withdraw my motion.
Okay. Well, then we're back to a,
We have an amendment on the floor. We have a motion on the floor. I know once the motion's made, it's on the floor. Wouldn't it take unanimous consent to withdraw?
okay, well, so you think we need to vote on it?
Do you need a moment to check,
Yeah.
find the parliamentary procedure book?
Yes.
Can we
it's,
stand at ease?
Commissioner Belson, I think you're right. You do need unanimous consent to withdraw the motion that's on the floor. So it is still there. I think we will. Mr. Caston,
Is that been confirmed by?
Let me ask you
staff?
this.
That was
Would
confirmed.
a motion to table until a specific time be in order?
To table the motion to withdraw?
Well,
That she withdraw.
to table the pending motion. The motion that's on the floor.
Mm-hmm. Yes. Well,
You need to talk to the chair, not to me.
Mr. Chair, I move the table.
all right. Where, Vice Chair Williams, did you have something?
He moved the table.
Yes, sir. Mr. Chair, I move the table.
All right. We need to
I'm-
vote on that.
I know what you're trying. Would it be a suggestion to that the proper motion might be adjourn debate?
All right. Motion to adjourn.
Vice Chair Williams, you hear that?
I think move the table.
From the standpoint
is
of
a-
that, from the standpoint that, and let me ask council, but I don't want table to kill it. But we just need to, if there needs to be some time.
Well, I think we could, if we table it, if we adjourn debate, then we need to possibly set a time to reconsider. And I think the sooner the better.
Well, it's not reconsider, it would be adjourn debate to a specific date and time.
Well, I think we need to set a specific date and time as soon as feasible.
Mr. Chair, I withdraw my motion. I don't have a date and time in mind. If someone has a date and time, then I think they should move forward with that. So I withdraw my motion to table.
Next week.
We're going to take a short break. We're in recess. We are back on the record as to the commission business meeting, and as to item number 4, we are going to adjourn debate. The matter will be considered on Monday at 11 o'clock. And that will be Monday, November 4th at 11 o'clock. Mr. Scarborough.
Moving on to the motor carrier agenda. In Part A, we have 3 applications that we can address these items together. Item A1 is in docket number 2024-282T, which is the application of Marsick 2 Movers and Storage LLC for a Class E household goods certificate. Item A2 appears in docket number 2024-283T. This is the application of Aaron's Transportation Service LLC for a Class C charter certificate. And item A3 is in docket number 2024-284T, which is the application of CLT Rides LLC for a Class C charter certificate.
As to items A1 through A3, as read by Mr. Scarborough, is any further discussion, or is there a motion?
Chair Powers.
Commissioner Thomas.
Thank you. I move that the commission approve the applications for Class C certificates in item numbers A1 through A3 as identified by Mr. Scarborough. A directive order will be issued for the application in the respective docket. So moved.
Thank you, Commissioner Thomas. Is any further discussion? Hearing none, we'll proceed to a roll call vote, beginning with Commissioner Thomas.
Aye.
Vice Chair Williams.
Aye.
Commissioner Williams.
Aye.
Commissioner Belser.
Aye.
Commissioner Caston.
Aye.
And I vote aye. The motion carries.
In Part B of the transportation agenda, we have 1 request for reinstatement of a certificate. Item B1 is in docket number 2023-120T, which is a request from Metro One Ambulance Incorporated for reinstatement of Class C non-emergency certificate number 9800.
As to item B1, as read by Mrs. Scarborough, do I hear a motion?
Chair Powers, I'd like to make a motion.
Commissioner Williams, you have the floor.
Thank you. I move that the commission grant the request of Metro One Ambulance, Inc. to reinstate its Class C non-emergency certificate number 9800. The company is directed to file any updated information as well as to come into compliance with all rules and regulations of the commission.
Thank you, Commissioner Williams. Having heard the motion, is there any further discussion? We will proceed to a roll call vote, beginning with Commissioner Carolyn Williams.
Aye.
Commissioner Belser.
Aye.
Commissioner Caston.
Aye.
Commissioner Thomas.
Aye.
Vice Chair Williams.
Aye.
And I vote aye. The motion carries.
Mr. Chairman and Commissioners, this concludes all business noticed before the commission today.
Thank you, Mr. Scarborough. We have, make it clear, we've adjourned debate by unanimous consent on item number 4, and it will be considered Monday, November 4th at 11 o'clock. If there's no further business this afternoon, I'd like to give everyone a little warning. Hope you enjoy your evening, but be careful because there are masked strangers in groups knocking on your door, making threats if you don't give them what they want. Some will even complain if you didn't give them enough. We are living in scary times. Be safe and help others. We're adjourned.